First, I'd just like to introduce Professor Bradley. So Professor Curtis Bradley is Duke's William Van Alstyne Professor of Law, Professor of Public Policy Studies as well. He teaches international law, foreign relations law, and federal courts. Professor Bradley is also the co-founding director of Duke Law School Center for International Comparative Law and serves on the executive board of Duke's Center on Law, Ethics, and National Security. He has contributed extensively to the Restatement Project on the foreign relations law of the United States. Prior to joining Duke Law, Professor Bradley worked as legal counselor in the Legal Advisor's Office of the U.S. State Department. He also clerked for Justice White of the Supreme Court. Professor Bradley has worked extensively on the issues related to the Justice Against Sponsors of Terrorism Act, and recently was invited to share his insights on ABC News, so we are particularly lucky to hear from him today. So without further ado, please welcome Professor Bradley.
Thank you. Thanks for the introduction. Thanks for coming at lunch to talk about this recent statute, and we might hear more about it. I'll try to connect it up with some recent even election events as I go along. I'm not going to take up the whole time because it's the kind of topic that I imagine some of you might have questions about even after I describe it, and so I'll try to have time so we can discuss any things that are on your mind. So it is a statute was enacted about a month and a half ago, Justice Against Sponsors of Terrorism Act. Everybody calls it JASTA, which is what I'm going to call it. And one noteworthy feature of it is the Congress overrode President Obama's veto. That's the first and only time Obama has had a veto of a statute overridden by Congress. They did it by very large margins, as I'll explain. One of the themes that I'll highlight, although there are many others I think as well, but one theme that I think will come out of what I describe is that this, like many examples in the area of international relations, illustrate how Congress as an institution often perceives the world and U.S. interests differently than the executive branch does. And that often does not depend on even the parties in control of the two institutions. It happens, of course, that Republicans have Congress, and for a small amount of time left, the Democrats have the White House, but this has happened in prior times when that's been different. And I'll give examples of that. And there's also different perspectives relatedly to the value of international law and the U.S. relationship to international law. And those institutions, I think, vary about that as well. So I need to give you a little bit of background because I don't know what people have already studied in this regard, so I won't assume anything. JASTA is going to be about something called sovereign immunity. So I need to explain, and I have had to do this a little bit when I've talked to the press as well, what is this thing called sovereign immunity that JASTA regulates? It has long been the case that as a matter of custom, not written down in a treaty, but as a matter of international practice and custom, nations are thought to have immunity if they're sued in another country's courts. So if you tried to sue any nation, France or any other nation in U.S. courts, the thought is they're entitled to immunity from that. Just like if the United States is sued in some other nation's courts, it would have immunity. Long-standing matter of custom. There's no general treaty on this. There ought to be. There's been some issues trying to negotiate one. But there is a long-standing customary practice, and the basic idea is that each nation is thought to be sovereign and independent of each other, and they shouldn't sit in judgment on each other. They shouldn't use their courts to be the adjudicator of what other countries are doing. The danger would be that if they do, it'll be very politicized. The other country's not likely to accept the results of the adjudication, and there'll be retaliation, and there'll be a lot of politicized cases around the world that just generate lots of friction and disagreement between countries. And the thought is that if there are differences, or if you think a nation's done something bad to your citizens or something, you have diplomacy, you have maybe agreed to international arbitration or adjudication, but you don't use your courts as the arm to sit in judgment on what they did. And the U.S. Supreme Court has endorsed this idea since almost the beginning of the United States. There's an old case involving a French ship called the Schooner Exchange case from the early 1800s, where the Supreme Court said that these owners of this vessel, the French allegedly took in a war, couldn't sue France because it's a sovereign and we don't use our courts to sit in judgment on other sovereigns, and we don't want them to do this either. And throughout the 19th century, throughout the 1800s, other nations agreed with that, most nations, European and others, and this was absolute. That is, no matter what the other nation did, you couldn't sue them. And so the United States couldn't be sued, and other nations could not be sued in our courts for basically any type of claim. It started to shift a bit by around 1900 or so, partly because more and more countries are doing commercial things. They're running state-owned enterprises, railways and things, and doing a lot of contracts and issuances of bonds. And it increasingly became, the thought emerged that if they're going to act like private companies sometimes, shouldn't they be subject to suit like a private company or a private individual would be sued? And some countries, particularly in Europe, started shifting to say, we won't let you sue if it's about a sovereign kind of public, big, high-level activity of a foreign government. But if they're acting like a company, they're acting like a private player and doing a contract, and they breach the contract, we think you can go ahead and sue them for that. And so they adopted something which we call the restrictive theory of immunity. It's no longer absolute. It only covers sovereign and public acts, I'll say more about that, sovereign and public acts, but it doesn't cover private and commercial acts. Again, this is all a matter of custom. You'd have to look and see what nations are doing, but that's basically what they're starting to do by the early 1900s. They're now being open to some suits against foreign sovereigns. It doesn't generate a huge amount of controversy. It could have, but it didn't. The United States is kind of a slow to come to this. Finally, the United States agrees with that trend. You can allow some suits based on commercial or private acts. The United States formally agrees to that in 1952. A lot of other European states had already gone in that direction. The way the United States agreed to it, the State Department just put out a letter, a famous letter called the Tate Letter, that says, from now on, we're going to agree to this more narrow restrictive immunity, which means you can't sue other nations for public and sovereign acts, but if it's a private or commercial act, you can. And the State Department just put out a letter, said that's the U.S. policy from now on. Similar to what a lot of European countries had been doing by that. Part of the thought was we didn't want, like the Soviet trading companies at that point, this is the Cold War period, to have absolute immunity, whereas if we had some sort of commercial activities, we wouldn't be receiving that kind of absolute immunity, say, in Europe. So the thought was they should all be on an equal playing point. Also, we didn't want the Soviet trading companies being able to do all sorts of things where our private companies would be sued and they couldn't be sued. It didn't seem equitable. So we agreed to go to this more narrow type of immunity regime, although kind of oddly not done in a statute, no treaty. This is something that international lawyers call customary international law, which most people, if you haven't studied international law, you've never really focused on that. But it's long been thought, actually, for hundreds of years, that certain customs of the international community bind nations. They're just as binding as treaties if they're well-established customs. And if you violate one of these things, you're breaching international obligations. And it is thought that immunity, at least in the restrictive form, is like that. That if you started to deny immunity for a public and sovereign act, you would be violating your obligations as a country, and you'd be in breach. And potentially there could be some kind of an accountability, an international tribunal if that were available, or something like that. Or at least condemnation from other countries. We'll see that some of that's happened with the JASTA statute, as I'll get to. So the United States says, okay, we'll go along with this 1952, the Tate Letter. That means you can start suing foreign states to some extent in American courts, starting in the 50s. So people do. We shipped you some grain and you didn't pay for it, all sorts of commercial disputes. And you can bring some of those cases. And the way the regime developed was the courts would try to figure out what's the difference between a public act and a private act. That wasn't real clear. This Tate Letter didn't explain how you would figure that out. So they'd run into big problems like, what if somebody sold a bunch of army uniforms to some other country? Is the failure to pay for that just like a commercial act? That is not paying money for a contract, sounds commercial. On the other hand, the army uniforms, that's part of a sovereign activity, equipping your military. That's like a high-level sovereign. So is it a sovereign dispute or is it a private dispute? The courts had a difficult time figuring that out. What they did to sort of cheat on that a little bit is if the State Department took a position in a case, they intervened and gave a letter to the judge saying, we think you go ahead and give India immunity in this case, they would just accept that. And then they'd stop thinking. They would stop analyzing it. They would just defer absolutely to the position of the State Department about whether to give particular entities, sovereign entities, immunity or not. And they wouldn't work any further on the international law side of this. It's really hard to figure out what the customs are. And the State Department told them they would just accept the State Department's view. Problem is the State Department didn't always take a position for a variety of reasons. And so sometimes courts had to figure it out. Sometimes they just deferred to the executive. And the decisions, it turned out, didn't look very consistent because sometimes the State Department would have political reasons for favoring India or some country, and a different case, the court might come out differently. So the case law was starting to look very inconsistent. The other thing that happened, it looked like a great power for the State Department. They get to decide cases. They don't normally get to do that. They get to tell judges how to decide whether to allow somebody to sue a foreign commercial company or something. The problem was they increasingly didn't like it because every foreign government was lobbying them, saying, you gave immunity last week to India, you better give it to Pakistanis, you better give it to some other country. And they were getting lobbied all the time to give immunity out since everybody realized they could control it in these American legal proceedings. So they actually stopped liking it as much and agreed with Congress eventually this ought to be regulated by statute. And they worked with Congress over a bunch of years to craft the big statute the United States has on immunity, which is the Foreign Sovereign Immunities Act. Long, detailed statute. We've had it since 1976, so it's been around quite a while now. And it governs any suit brought in an American court against a foreign sovereign or any of its entities, its state-owned entities. So comprehensive. And if you do any litigation, by the way, after law school, it's very possible you're going to run into the statute. I did general litigation for teaching, and I had no idea I was going to run into it. You just run into the statute because it turns out a lot of nations, I ran into a case we were doing with insurance coverage, and Ireland owned like enough shares in some insurance company. All of a sudden, Foreign Sovereign Immunities Act kicked in and has all sorts of special rules. The core of that statute says if you sue a foreign sovereign or one of its entities, it gets immunity, unless you can show that one of the exceptions in the statute for immunity is satisfied. So the plaintiffs have to kind of prove that one of the exceptions Congress identified in 1976 exists to immunity. Otherwise, they're out of luck. And the case is dismissed actually at the jurisdictional phase. Just get rid of the case right from the beginning, unless you can show your case falls in one of the exceptions. So you would immediately, the core of the statute is what are those exceptions in 1976. The most important one, and from a litigating standpoint, not one I'll focus on, is the commercial activity exception. As you might expect from the way I described how immunity custom evolved, you can sue foreign countries for their commercial activities if they breach things, if there's certain kind of connections to U.S. commerce in the U.S. And there have been thousands of cases brought under the Foreign Sovereign Immunities Act. The large majority are those sorts of cases. Those aren't the only kinds of disputes people have with foreign states, though, of course. So another major area would be torts, other than contracts and commercial things. What if a foreign sovereign or its officials harm you in some way or take away your property or something? You might have a tort claim. And what Congress decided in 1976, for better or for worse, was to say you could only sue foreign governments for their torts if you were injured in the United States or your property was damaged in the United States on U.S. soil, leaving out of the ability to sue all of the many foreign torts that might occur, human rights abuses, terrorism, things like that, not something you can sue about, because those aren't commercial activities, and the tort damage at least doesn't occur here. The thought was, you might imagine, for a justice point of view, you'd want to be able to go after foreign states for doing terrible things, torturing people and killing them, and all sorts of things that sometimes happens. But these would be very contentious types of adjudications. The foreign state would deny it. They would not want to engage in discovery that you would have in litigation about what the decisions they made in their foreign country about their police force or their military. And that's how these cases would look. And it didn't seem to fall in the restrictive type of immunity. That is to say, it didn't seem private or commercial. It might seem terrible, but it's public and sovereign kind of military and police activities, not the private commercial acts that eventually everybody agreed you could sue about. It really seemed to fall on the sovereign side. And for good reason, because it's likely to generate a lot of friction and dispute and retaliatory suits if you start allowing these cases to proceed. And Congress realized that, so it didn't allow those unless there's a tort here. And the one example they give in the legislative history is, what if a diplomat is driving around and accidentally hits you? The problem, it turns out, is you can't sue the diplomat because diplomats have their own immunities under actually a treaty, diplomatic immunity. Well, that doesn't seem right if they cause injury. So the thought was, well, if they're causing that traffic accident here, you ought to be able to at least sue their employer, that is the state. And this was an opportunity, this tort exception in the Foreign Sovereign Immunities Act allows you to do that because the damage or injury obviously occurred here. That legislative history has been important to a lot of courts looking at this exception, and just about all the lower courts have said what Congress really had in mind is also the tort occurs here, not just that the damage or injury, the effects of it occur here, but that actually the foreign state did something wrong here, negligence, intentional tort, something. And they've limited the tort exception, and this is really key for understanding JASTA, and what generated it was you can only sue for torts when basically the foreign state did something bad here on U.S. soil. And that doesn't happen, and certainly no intentional torts. One would expect that's not going to happen very much. And the negligence kind of traffic accidents, not generating a big sort of controversial issues. So tort exception, very narrow, limited to the United States, and of course limiting it so that the tort itself has to occur here. Starting in 1996, Congress decides that's too limited. Partly there's a lot of terrorism going on in the world, and U.S. citizens are injured or killed abroad, and Congress thinks, you know what, maybe we limited this too much. So they add another new exception in the statute in the 90s called the state sponsor of terrorism exception. And the way it works is if you're a U.S. citizen victim of terrorism or a couple of other things, terrible conduct, abroad, you can sue the foreign state for having done that to you if that foreign state is on a list that we call state sponsors of terrorism. And that list, it turns out, is maintained by the U.S. State Department, by the executive. So the U.S. State Department, through some regulations, which it changes from time to time, has a list of the countries it considers state sponsors of terror. And if that a country's on that list, this new exception in the 90s, which we still have, allows you to sue if they commit terrorism or torture, extrajudicial killing, summary killing, against you or your family members outside the United States. So that's much broader than the tort exception, which was limited to things in the U.S. The one big limit on it is only for state sponsors of terrorism as the defendant. In 1996, when this was first passed, there were 6 countries on the list. They were Iraq, Iran, Syria, Sudan, North Korea, and Libya. And you can, if you go through that list in your head, you can imagine why not all of them are on the list anymore. For example, Iraq was taken off the list after the war the United States had in Iraq and the regime change, just to give an example. Libya, some of these maybe they should be back on the list, but in any event, a lot of changes were going on in Libya as well, and they were taken off the list. Why North Korea is off the list? It was an effort to give them something in return for some things about their nuclear program at one point. Maybe they should go back on the list, but they're not on it. We only have 3 countries left on the list at the moment: Iran, Syria, and Sudan. So if it's not one of those 3 countries, you can't sue under this exception, state sponsors of terror. Notice, by the way, to get to JASTA, Saudi Arabia is not on the list. And most countries aren't. We have 193 countries in the world, 190 are not on the list, and most will never possibly be on the list, and they know that. That limit, which is controlled by the executive branch because of statutory delegations that have existed for a long time about who gets designated as a terror sponsor, that limit has probably saved that 1990 statute from generating too much controversy abroad. The European nations don't like it. They've criticized it. I'll explain some things they've said about it, but they know they're not going to be on the list. There's no danger that Germany is going to be added to the list, for example. So, and it's mainly targeted at rogue states that very few nations have much sympathies for anyway. So those nations complain. Iran has complained bitterly about this since the 1990s, but they don't necessarily carry that much weight in foreign affairs. And so the controversy about this has been pretty contained, and the executive has some control over it by narrowing the list as it's done. If you looked at treatises on international law, particularly outside the United States, you would find most of them saying this particular exception violates custom of immunity. And the State Department, the other thing about this is the executive strongly urged Congress not to enact this exception in 1996. They said they were really worried about the reciprocity implications and the erosion of immunity that this was likely to cause, and the foreign relations friction it might cause with even our allies. And Congress said, thank you very much for your insights, and we're passing the statute. Something that seems to happen repeatedly in this area and things like it. What then happened after 1996, not surprisingly, since this was Congress's intent, many multi-million, and I'm talking, 300, it became like one of the district judges, I think, was issued like one of those stamps, an ink stamp, just said $300 million on the bottom, and they just stamped every judgment $300 million. And a bunch of things, for whatever reason, had like $300 million as the award, were starting to get issued against Iran, Cuba, and Libya in particular. Those were most of the suits. Hard to get really anything going against North Korea, for example, for a variety of jurisdictional reasons. But these other ones, they had a bunch of suits saying there's terrorism, it harmed American citizens. It was the Brothers to the Rescue killing over international waters by Cuba, terrorist support by Libya, lots of Iran-sponsored Hezbollah kinds of things, and people sued for very large sums, and they won. Partly because Iran would refuse to even show up for the cases, so it was kind of easy to prove your case when there's no actual somebody arguing to the contrary, and they refused to participate in discovery and things. And so they got default judgments for hundreds of millions of dollars for the plaintiffs. And these are sympathetic American plaintiffs, some of whom were killed and their family members are suing. Congress is very sympathetic. They ran into a big problem. Okay, you got a $300 million judgment. Now how do you get your money? Do you say, Iran, could you please give me $300 million? You could try that. It turns out not very much money is coming your way if you do that. So any guesses about that? They try to attach and find assets somewhere they could get the court to attach. The problem is those are not countries, unlike Saudi Arabia, that's likely to have a lot of just assets lying around for attachment. Mainly all that was existing, other than diplomatic property, which is supposed to be immune from attachment, is some frozen bank accounts and things from the times we've had crises like the Iran hostage crisis and the Cuba revolution. We've frozen assets of the regime. And the executive branch controlled that. And so the plaintiffs wanted to get into that. Executive branch bitterly opposed that. Do not let them attach these frozen assets. It's the only leverage we have. The executive says if we ever start improving relationships with Iran or Cuba, interesting, we've had new developments with both those countries in the last couple of years, and they would like to control that leverage of these frozen accounts, not having private lawyers start doling it out to their clients. Congress said, thank you very much for your views, and they started passing literally about 6 new laws throughout the 90s and 2000s trying to make sure the plaintiffs could get these assets. At one point, they were having trouble finding enough assets, so the U.S. Treasury, anybody in the room is a U.S. citizen, the victims, thank you very much, you paid for the judgments because Congress authorized from the U.S. Treasury the compensatory damages parts of the judgments to be taken if the plaintiffs were willing. Some of them waved it off, figuring they could do better. But that wasn't available, and some of them got millions of dollars from the Treasury as opposed to the Cuban or Iranian or Libyan assets. But Congress kept trying, and there was a law just enacted a couple of years ago where they found a big pot of money owned by like a subsidiary of an Iranian company, a state-owned company, and the judge was resisting, saying he didn't think it was available for attachment. So the plaintiffs went to Congress. They got a law that says in the case pending, Peterson versus Bank Markazi, in that particular case, said Congress, those assets the plaintiffs are trying to get are subject to attachment. That's the law. And the Iranian bank objected to the law, saying, how can Congress pick out a particular case pending, tell the court what property is available? It went up to the Supreme Court last year, Bank Markazi versus Peterson. The Supreme Court said, no, that's fine. It's a very narrow statute, but Congress can change the law. It's not really a constitutional right. You can change the law about which property is subject to attachment. They just happen to do it in the middle of a case, mainly about that case, but the court didn't find any violation of rights. Iran was very unhappy about that, as you might imagine, so that's millions of dollars that's now being attached in that case on behalf of the plaintiffs. So that's all going on. That's under the 1990s exception with lots of additional statute Congress has passed to try to get them money. In the last 5 or 6 years, victims of 9/11, their families, but they were also, of course, offered compensation through the U.S. Treasury. Some of you probably know there's a Victims Compensation Fund, and it has given out an average of about $2 million per family member. But a lot of people don't think that's enough, or they didn't take it, and so there are a lot of people thinking, and also it's just coming from the U.S. taxpayers, and the thought was, should be able to get some redress from perpetrators of these terrible events. So they've been trying to lobby Congress for years to particularly let them sue Saudi Arabia. And there have been allegations from right after 9/11 that Saudi Arabian high-level officials were connected to the hijackers, supported them, encouraged them, financed them, etc. And plaintiffs believe that, and they think Saudi Arabia, a rich country, should really be held to account. So it's not even just fully about getting the money, it's holding them to account for the terrible things that happened on 9/11. Now, it's a complicated, and I don't know the facts, and I bet it's hard to find people who fully know the facts, other than maybe the Saudis themselves. The 9/11 Bipartisan Commission report looked at that particular allegation, which was a serious one, and said, although there were some indications of some connections between some Saudi officials and the hijackers, there wasn't enough evidence that they had before them to have a direct link with the Saudi government. So that was their conclusion. The plaintiffs are not satisfied with that. They think that doesn't really finish the investigation off, and I think some people in Congress feel the same way. There were some not missing pages, held back pages from that report about this particular topic, since it's such an inflammatory issue with U.S.-Saudi relations. Those new 28 pages have come out with some redactions. Not a smoking gun, although again, same suggestion that there might be something going on, and so the plaintiffs don't think certainly it's been put to rest. So Congress finally was persuaded. It's an election year. That's had a lot to do with JASTA getting passed this time. I mean, this has been proposed for 6 years. And it's an election year near the end of the Obama administration, and Congress starting to become very receptive to passing a law allowing a suit against Saudi Arabia for allegedly facilitating the 9/11 attacks. They couldn't do it under the FSIA, the Foreign Sovereign Immunities Act, because obviously the tort, whatever tort it is that Saudis didn't occur here. The hijackers did significant torts in the United States, but there was actually a case pending against Saudi Arabia a few years ago, and the plaintiffs had no evidence that Saudi Arabia directly committed the hijacking of the terrorism. And that's what the case law had required. You've got to show that the foreign state directly did something in the U.S. So the plaintiffs were losing that case, and that's why they said we really need this statute to do some things to sovereign immunity law to make this easier for us to litigate. And Congress became quite receptive to that appeal. So that led to a proposed JASTA statute, and that eventually gets passed a month and a half ago. What it does, there's some complications in it, but basically what it does is it creates another new exception to immunity. In addition to the state-sponsored terrorism one, this is separate. And it says you can sue any foreign state, foreign nation, for having done things outside the United States that ends up facilitating terrorism inside the United States. And it doesn't go into detail about what that might be, but that leaves it to be litigated about whether they have a sufficient link from what they did abroad to bad things that happen here. And Congress, and that, by the way, and not limited to state sponsors of terrorism. Any nation can be sued under this if you can try to prove that they did some things abroad that help facilitate terrorism in the United States that cause injury or property damage here. The executive branch, this is true about every other intervention like in this area, but the executive branch was heavily opposed to JASTA when it was being developed. And President Obama tried to make that clear and did veto this, as he had threatened to do. And his veto message, I'll just give you some ideas from the veto message. He says he had three concerns. First, he says, and this is always what the executive says, it's just not a good idea to delegate the investigation and condemnation and enforcement of foreign relations problems to private lawyers and their clients. It's too disaggregated. We can't manage it in a coordinated fashion. It's just not a good way to conduct foreign relations to have the litigation process decide our relationship with Saudi Arabia, for example, which has a lot of facets to it, not just this one, but a lot of others like fighting terrorism and things like that. This is a common concern that the executive has about authorizing more litigation. Second, related and more specific to this, he said he was worried that if we did this, we would undermine strong principles of sovereign immunity that the United States probably benefits more from than any other country in the world. Why does the United States benefit more than? Because it has bases everywhere in the world, has service personnel everywhere. It does a lot of controversial things around the world, predator drone strikes and things that a lot of countries think are basically our form of terrorism or war crimes. And there'd be lots of people who'd love to sue the United States for all of that, and our officials and our service personnel. And we have maintained around the world an argument that, no, you can't do that because of strong principles of immunity, and it protects us around the globe. And he says if we start chipping away because we think terrorism's terrible, which it is, other nations will start chipping away too and saying war crimes are terrible and predator drone strikes are terrible and things like that. And how are we going to be able to stop that and object to it if we're going to chip away on our own end? And immunity is going to start to erode. And then he said, finally, he's really worried just even in the short term about the friction it's going to generate, both with allies, say, in Europe, who certainly are not going to like, because any nation can now be sued under this. It's not even state sponsors of terrorism. And with even Middle Eastern countries and others who might be targets, because as complicated as those relationships are, we do rely on them for intelligence about terrorism, for some cooperation in terrorism and other activities, and this is probably going to reduce or maybe reduce that cooperation. And he thinks, again, that ought to be something that should be done thought through by the government perspective, not through litigation. Just as a point of full disclosure, while this was all happening, I wrote an op-ed in the New York Times. It said before Obama had to veto it that said similar things, that I had concerns about this. So that's just my take on it. Obviously Congress did not agree by any means. In fact, the vote to overturn, so the vote in Congress to pass JASTA the first time was unanimous in both houses. Democrats, Republicans, kumbaya, in harmony, no disagreement. In fact, not even showing up to vote. It was all done by, they're out of town and it passes. They have special procedures when they're not, you don't even have to show up to vote. That happened for JASTA. It got passed without any real deliberations. Unanimity. And then they had to decide whether to overturn Obama's veto. The vote in the Senate to do so was 97-1. Good old Harry Reid sticking it out for the president, but everybody else saying no. We're overriding your veto. And it was a little closer in the House, 348-77. So there were some members of the House, mainly Democrats, that stood up for the president. But obviously overwhelmingly overrode the veto for the first time in Obama's presidency. Well, very quickly during this period, the European Union, 28 nations, maybe 27 pretty soon, but 28 nations, wrote a strong letter to the executive saying, this is terrible, you just violated international law with JASTA, we think this is going to really cause reciprocity problems and erode principles of immunity, which we thought you liked, and we're very unhappy with this. So the European Union has now weighed in on that and expressed grave concerns. The other thing that may happen is that this may, well, it is probably being litigated in an international tribunal, this issue of whether the United States just violated international law with JASTA. What happened around the same time is Iran really unhappy about the state-sponsored terrorism exception and really unhappy about this Bank Markazi case, where now their bank assets were being grabbed based on this new legislation, has finally gotten around to suing the United States in the International Court of Justice, which sits in The Hague in the Netherlands. Can they sue the United States? It's complicated, maybe. There's this old 1955 treaty between the United States and Iran. Iran was a very different place back then. This was the Shah of Iran. But treaties just keep kicking around. I tell my students this in classes, like treaties just keep going, often, even with regime changes. And we still have that treaty with Iran. And there's a clause in there that lets them sue us in the ICJ about certain kinds of things, the International Court. They're using that to try to see whether the court will say that, not JASTA, the state-sponsored terrorism exception violates international customary norms of immunity. I think it's a reasonable prediction that if the International Court decides it has jurisdiction under that treaty, and that'll be debated, it'll take a year or two before we even know that, the United States will then proceed to lose that case. Because we know what the International Court thinks about immunity. Just from a few years ago, they had a case between Germany and Italy. Italian courts wanted to allow suits against Germany for doing very terrible things, rounding people up in Italy and deporting them to death camps. Hard to imagine something much more egregious than that. And the International Court said, no, it doesn't matter how egregious it is. Maybe this should be remedied if you haven't already tried to remedy it through arbitration or something. But you can't use your courts to do it. That's sovereign and public acts. It will be heavily controverted, and then it'll just lead to other retaliatory suits. And the International Court says international custom may allow you to sue for commercial things, but not something like that, no matter how egregious it is. If that's true, you can't sue for the Holocaust. It's hard to see why you can sue for terrorism. Terrorism terrible as well, but probably not worse than death camps and things like that. So that's the international. Interestingly, of course, the United States applauded heavily in favor of the Germany versus Italy decision. the United States likes that decision, because that's exactly what we have to argue when we're sued, if we are, for predator drones or war crimes. Just read in the paper this morning that this is not entirely on point, but the International Criminal Court is seriously investigating whether to bring war crimes charges against the U.S. for conduct in Afghanistan. These are real possibilities the United States confronts. And the United States normally argues we like the strong immunity. You have to resolve things through diplomacy, not through suing or criminal cases in national courts. But Congress obviously passed it unanimously the first time and almost unanimously the second time. We had a strange coda to that event, the development, though, as some of you may have read in the paper. Leaders in both houses came right out right after overriding Obama's veto, saying, oh, nobody told us there'd be problems with this statute. Nobody told us it might generate problems for the U.S. forces and bases overseas. People have been sort of talking about that for about 6 months. But nobody told us about that, says Bob Corker, who chairs the Foreign Relations Committee, Mike McConnell, Paul Ryan. And they all came out and said, you know what? We're not sure this was a good statute, which we just passed and overrode somebody's veto on. Maybe we need to amend this, is what they all said. And 28 senators signed a letter saying, we're committed to trying to improve this and fix some problems with it that we just passed. Might have thought that would have been even better before they passed it. But election year, they sort of quietly indicated, not quietly even, that, look, November elections are coming. We're not passing a statute for victims of 9/11. We're not fixing it right now. But there seemed to be an indication that after the election, some of them at least seemed committed to the idea that maybe this is too broad and we needed to pull this back to reduce some of the danger for the United States of setting a bad precedent for our own immunity, reduce friction with Europe and other allies. Probably they're not going to try to fix friction with Saudi Arabia. That maybe is probably not is what they care about the most. Some of them even, kind of, this is how politics works in D.C., came out and said, Obama is truly a terrible president because he just had his veto overridden, which was interesting since they're the ones who voted to do that. So that's the kind of dialogue that they're having about this. Now that the election is over, the dialogue might change. If you watched, not that you were paying attention to this particular issue in the debates between Clinton and Trump, both of them like JASTA, they say. Trump went out of his way to criticize Obama for vetoing such a good victims' compensation bill. But Clinton even said she's, of course, supporting JASTA. It'd be very difficult for either one of them to have said otherwise. So what the new president-elect Trump will do on this, I have no idea, though, and I don't think anybody does. What his position would be on it once he's actually listening to whoever his Secretary of State, there's a lot of discussion about that today, too, has to say about it, given their allies don't like it, given that we worry about our own immunity for our troops and everybody else, which he probably would care about. It's conceivable that Trump would do what many executives do, which is to think that this is not the greatest way to conduct foreign relations. But I have no idea, and I don't think anybody probably would. Another possibility, I guess it's possible that Obama would try to get an amendment to JASTA before Trump goes in. It's not out of the question. And given that some people in Congress have said they're willing to think about that, Saudi Arabia has hired very expensive lobbyists to try to help that, so it's conceivable this will happen. And I'm happy to talk about how it might be narrowed if there were any effort to amend it at this point to try to reduce some of the problems that at least the executive believes it triggers. I'll just throw out three and then I'll end to see if there are any questions. So one would be giving the executive branch the ability to basically stop the litigation for periods of time if it's in the national interest. There are other statutes that work like that. Plaintiffs would hate that, because particularly the president's invoked it, because that would stop them from being able to sue. Limiting the law just to the 9/11 attack so the rest of the world can relax about anything else that might happen probably would reduce some of the concerns, although not all of them. And then, or maybe limiting it just to allow you to sue Saudi Arabia, which is what the plaintiffs really want. Because then, like state sponsors of terrorism, the rest of the world could say, well, at least we're not on the list. And that seemed to have helped with the 1990s law. So those are some of the things that people have been talking about. I have no idea what the odds are that Congress will revisit that. Once the statute's out there, there's so many other priorities that Congress and the new president will have. I guess my own thought is probably it's unlikely we'll see any changes in this law until there's some new crisis with some other allies or something. That may take some time. So let me stop there and see if there are questions about this saga. Yes?
Well, first of all, thank you so much.
Yeah,
I
sure.
know that for a lot of us who've been following the news and have a lot of thoughts and questions.
Yeah, sure.
It's very helpful to have this laid out for us.
My pleasure.
I have a question actually regarding consequences you listed kind of three major consequences for the potential consequences for the U.S. abroad. And one of them obviously was that this kind of countermeasures, countersuits that we might see. Now I understand that our military bases, at least, we only put military bases in countries where we have a treaty with them that immunizes at least those soldiers from suit. So I was wondering, therefore, who's left? Is it contractors? Is it CIA? Who are we worried about?
Sure.
And secondly, is this really the concern, or is this just, from your opinion, or is this more just an easier political rhetorical device, other than things like how complicated it will now be for the executive to manage its foreign relationships, which I think is probably much more important, but harder to communicate?
Sure. Oh, good question. The base issue is complicated because you're right, we have status of forces agreements which try to limit the local country's jurisdiction over our personnel. It's not absolute, though, and there are all sorts of exceptions. So you have to look at each arrangement, and it's not as if there's no possibilities there. You mentioned CIA. So CIA is an example. Italy trying to bring criminal charges right now against our CIA officials for things that were done in the war on terror. Those are more realistic. Civil suits against the U.S. government as a whole. So just like a suit in the United States against Saudi Arabia as a whole, you could imagine the United States as a government being sued by people alleged to be harmed in other countries. So whether it be their business, some factory was blown up, or somebody with their family members were killed, the same kind of thing we're talking about here. You could imagine the U.S. government. And then it would be issue, if they won, how would they attach property? But the U.S., that's when we mention things like facilities and bases and things, is that we also have the physical presence abroad that people might try to attach those kinds of assets. So now, when I talk about reciprocity, what I always emphasize is it's not necessarily that the United States would see terrorism exceptions like ours and that might somehow get applied, because I think a lot of people in Congress say, we're not going to commit terrorism, which is fair enough. I think the worry is, to give an example. In Belgium in the 90s, Belgium passed a law that allowed criminal cases to be brought for terrible human rights abuses, basically. And a bunch of cases were now initiated against Kissinger, First President Bush, a bunch of U.S. officials, Israeli officials. The United States heavily protested that, arguing that human rights is important, and although we deny that they did these terrible things you're saying, but you can't open it up to this. This is going to be trying to conduct massive friction and diplomacy in your criminal system. And we persuaded Belgium to amend the law and pull back. That's the kind of thing. It's not directly the same thing we're doing, but it's the kind of thing we've already seen in some European countries and others. And the issue, and it's just a question, will doing stuff like this make it harder for us to stop those sorts of developments, which we protested before? Or is it all about custom, and it looks like, countries are pulling back, and if it's a human rights problem or a war crimes problem, open it up. And I think that's a worry. The problem in persuading Congress about that, you can't show them like tomorrow there's going to be a problem necessarily. You can talk about the CIA case and things like that, but it's a little bit different. And so it's one of these issues. Do we take a risk on sort of eroding immunity in the next 20 years or not? And Congress said they were happy to take the risk. The executive's more worried about that risk, but it's hard to prove that it's going to cause this immediate harm. And that is an objection to what I said, I think, which is fair enough. Other thoughts or questions about this? Yeah?
How have other countries dealt with these same issues?
Yes. Yeah, good question. If you look at the immunity laws of other countries, for example, you don't find anything like what the United States has. There's a country that I have to make one exception now, because about 2 years ago, Canada actually adopted their own state sponsor of terrorism exception. So it used to be the United States was the only country in the world with any like the 1990s. Now, when the government has to defend it, it says, well, there's Canada as well. There's two countries. And so, but countries in Europe have immunity acts just like the U.S. does, and it's limited to torts committed on their soil, just like our 1976 law. And they don't think they can use litigation to go after countries as entities or their state-owned enterprises for things they do outside of the territory, even for terrorism. And they, of course, suffer terrorism as well as the United States. So they just haven't gone there. It's possible they will. And they might be persuaded. Of course, a lot of things are going on in politics in other countries, just like in the U.S. You could imagine that eroding, but it hasn't. The worry is they would also be sued, and they don't want to open it up. And so they've held the line, even though they've suffered from terrorism as well. And there's a lot of public pressure to do otherwise. Imagine victims have good complaints that why would you immunize them? And it's complicated with Saudi Arabia because I don't know what their links are. There's a lot of suspicion, and I get that. Saudi Arabia's relationship to the U.S. is very complicated right now. It's not nearly as strong as it used to be. We are less dependent on their oil, for one thing. And we have lots of issues about their conduct in Yemen and places in the world, and whether they're always helpful in the Middle East. That's become very fraught. So part of what's happening is I think things that would have been valuable in the Saudi relationship are less apparent. So Congress is more willing to erode it. But that hasn't happened in Europe yet. So we'll see whether 5 years from now I would give you a different answer than that. You have a question?
Well, just
Yeah.
a little bit more detail. So Iran and those other countries have not created...
Yes. No, that's good. So I was talking mainly about Europe. You're absolutely right. So after the 90s law was passed, Iran immediately passed its own version of as a retaliatory measure. Even before JASTA. The state-sponsored terrorism exception, once we passed that, Iran passed their own U.S. sponsor of terrorism exception, basically. The problem for Iran, I don't mind this problem that Iran has, is they can't get at our assets, it turns out. They don't seem to have any practical ability. And this would be true. The U.S. has this problem, too. No other country recognizes the legitimacy of our terrorism prosecutions, cases. So if you're a plaintiff and you want to take that judgment abroad in Europe and get it enforced, probably not going to happen. That's true of Iran, too. They can't take their judgments from Iranian courts and get anybody else to respect them. So if we don't have any attachable property, all we have is an embassy, which under international law, that's the one thing you're not supposed to attach. And if Iran did that, we would just close up the embassy probably. And so they don't have any property to go after or money. I think there are big judgments that some people in Iran have gotten against the United States, but they just sit there and the United States ignores them. The difference is we had frozen assets from Iran and bank accounts that we've been able to grab. And of course, we've given Iran some money back recently. That's a different thing. If you remember the big pallets of money given to Iran, that was a different issue, which is that the Obama administration got flack for, which is during the Iranian Revolution, when they came to power, they had given the United States a bunch of money to sell them things like arms. And we got the money, and we decided not to give them the arms, which may be understandable at that point, but we kept the money. And as part of the recent, somewhat controversial exchange with the Iran nuclear deal, we gave them, $1.5 billion back. So there's money flowing both ways in a sense, but our courts are attaching money that we have access to Iranian funds. They just don't have the same ability. But yes, this tends to produce local laws that are reciprocal. So far, the United States has been lucky. It hasn't been in countries where they would really be able to do anything about it. If it happened in Europe, it would be a huge problem because the United States would be much more likely to have vulnerabilities in a country in Western Europe. Okay. Other questions? Yeah.
Sorry, I
Yeah.
just have more questions.
Of course.
More questions.
Yeah.
But I should have time for one more. If anyone else wants to after me. So we currently have a president-elect who has, at least as part of his campaign rhetoric, quite loudly declared his preference for torture, which is, as we all know, is Kogan's.
Yes.
I wanted to ask you. You mentioned, for example, the issue of sovereign immunity with the Nazis in Germany. I wanted you to maybe expand a bit on universal jurisdiction.
Sure.
So, how were we able then afterwards to prosecute Nazi officials
Sure.
following the war?
Right.
And secondly, in your personal opinion, and this will be completely off record, if you think that considering the direction the country, considering what's happening now, would repercussions be? And again, as an Israeli, so I thought, would repercussions be so incredibly terrible?
Israeli courts have had to weigh in on lots of these issues themselves. So one thing that your question about the sort of post-World War II Nuremberg and the like, which is an important point to just kind of keep in mind, it is accepted that notwithstanding all this immunity law, if nations agree on some tribunal, some international tribunal, so the International Criminal Court is our current, the U.S. is not a party to it, but 100 nations are, they can take a treaty and override immunity. So in the International Criminal Court, if you're subject to their jurisdiction, the United States has tried to avoid being subject to their jurisdiction, but if you are, African countries obviously seem to be, a lot of their leaders are pulled in. By treaty, all countries that are a party have waived their immunity. So immunity is not a problem in international tribunals. Now, the Nuremberg Tribunal was done as an international tribunal by the Allies, the occupying forces in Germany, and they took over the laws of Germany and overrode Germany's immunity, basically. And so it's just a very unique kind of situation that would not be true for these situations we're talking about. And now the Eichmann case in Jerusalem is more complicated. The UN Security Council actually said that was a violation of international law, so it's complicated. But most people don't have much sympathy, obviously, given he was a high-level war criminal. So there are instances, and you're absolutely right, there's this idea that for certain absolutely egregious crimes, that nations, if they can get custody, they got Eichmann, by abducting him, if you can get custody, you can try them for atrocities. And even if it's not an international tribunal. And Europe has started to drift in that same direction more generally. This is the Belgium statute from the 90s. They started to drift. The problem was all sorts of politicized cases against Israeli officials, American officials, and others started to get generated by Palestinians. And the Israelis finally started getting cases generated against the Palestinians as retaliatory measures. And it didn't seem to produce a good dynamic. Whereas we can probably live with a one-off Eichmann terrible war criminal case. But when it starts getting generalized, it looks like it's hard to maintain. But the concern about JASTA, or the good news about JASTA, if you like it, is it might be that this is an invitation to do more of that. That is, to have nations think that they can handle some cases about terrible conduct. Now, you mentioned torture. That's what a lot of European countries have been somewhat open to from the Bush administration, CIA cases about rendition and torture. If it's true that Trump, I don't think we should assume anything from what we heard during the campaign. Just that's my view. It doesn't have to be off the record. That I think everybody's saying that. If it's true that we started torturing people or doing something that people would call torture, yes, I think that it alone would be likely to produce some efforts to exercise jurisdiction, and it's one of the reasons, maybe not the most compelling one, to watch out for doing that. And I think in that debate, JASTA would be cited as, look, you recognize egregious things should be adjudicated. Torture is egregious too, whether you agree with that or not in the United States. We'd have to debate that, I think. And that's the worry that I think the executive branch has, is that you're just inviting that kind of a dialogue in ways that probably the United States will find itself on the receiving end of it, even if we don't do torture. I think predator drone strikes and other military activities are already generating lots of angst around the world. Good question. Any last question? You can see, who knows what's going to happen, but at least you got a little bit of a view of what's happened in Congress recently, and I don't know what's going to happen now with the new president-elect. So there you go. Yeah.
Just as an old guy, doesn't this boil down to one fact, that it is all politics? If everybody is doing what we tell them to do, that is fine. But also, and I wonder what did Saudi did that now we are not as friendly with Saudi as we used to be.
Yeah.
Is it because they killed that Shia mullah during the conversation and thought regarding the nuclear, or there was something, there is something else? All of a sudden, we don't like Saudi. Now, you mentioned because we don't need oil anymore.
Yeah.
But are they doing something that we tell them to do and they are not doing it?
Yeah, that's a good question. And asking whether it's all politics is a big question. One of the worries that led to the Sovereign Immunities Act was it was so politicized. It depended on the particular relationships we had with that nation at that particular time that it seemed to swamp law doing the work here. And one of the ways, if you were a critic of this, would be to say, that's happening again, but in Congress, not through lobbying the executive, that this is just so being driven by the politics of the moment, which is, I think, part of your question. And one of the concerns is, does that mean international law is just all kind of talk and not really something that's mattering in this discourse? Since we always said that we thought international law limited your ability to sue and that immunity was important. I think there are issues about like coordinating with them in Yemen and whether they're being constructive in the Middle East. I think those are big issues. The only sort of positive side I'll say about it is, we'll see whether anything comes about it. A bunch of people in Congress have publicly now had reservations saying we're worried about what we've done in terms of the law side of this. They didn't have to do that. They don't want to help Obama. These are all Republicans. They didn't particularly want to help him out. So yes, I think politics is a lot of this. And the politics of the executive and Congress, as I said at the beginning, are probably very different. I'd like to think that Europeans' views on this and the law part of this will matter, and maybe some of these senators and Congress people will come back to that. But big topic, as you just recognized as well. So anyway, thanks everybody for coming, and I enjoyed it so much.